Probate has been granted, what's next? My name is Kerri Thomas and I'm a solicitor here at Clarke Hemmerling Lawyers. We have previously talked about what probate is and that an executor is responsible for making an application to the court for probate, including giving an accurate list of all assets and liabilities of the deceased. If the court is satisfied that all the documents submitted to it for the grant of probate are correct, the court will issue a sealed document called a grant of probate, along with certificates for each estate asset held by the deceased. The certificate gives the executor the authority to deal with each asset. Deal with generally means sale of assets. For example, to sell the deceased's home, the executor will need a certified copy of the grant of probate and the certificate from the court to effect the sale of the property. Most companies and financial institutions require probate to be obtained before they will release funds back into the estate, such as banks, superannuation funds and residential care providers, to name a few. Once an executor has the grant of probate and the certificates, all entities can be written to and provided the relevant documents so that the assets and funds can be released to the executor. The executor is responsible for repaying debts, including any tax and outstanding liabilities of the estate, before they can distribute any assets to beneficiaries pursuant to the will instructions. After selling assets and paying the deceased debts, before any distribution of the estate can take place, the executor should prepare a distribution report that accurately records all of the assets and monies called in and what has been paid out from the estate in liabilities, as well as what is to be paid to beneficiaries keeping with the terms of the will. The 6-month rule. Once probate has been granted, the executor has called in the assets and paid liabilities, they are able to distribute the remainder of the estate to the beneficiaries. Executors should, however, be aware of the 6-month rule. In South Australia, claims against the estate of contesting of a will can happen within the period of 6 months, following the date of the grant of probate. If an executor distributes the assets of the estate to beneficiaries earlier than the 6-month period after grant of probate, and the will were to be contested successfully, the executor will be exposed to legal risks and potentially payment to the successful contester. Do I need to appoint an estate lawyer? You do not need a lawyer to administer an estate after probate has been granted. But as you can see from what we've talked about, there is a lot of work involved and a great deal of responsibility being an executor. This is where estate lawyers come in and can be appointed to assist the executor with administering the estate, certify documents and maximise streamlined systems for efficiency when writing to the different entities. When a lawyer is appointed, estate funds can be paid to the firm's trust account and all liabilities paid from estate monies, including any executor expenses they may have incurred in administering the estate. An estate lawyer will prepare the distribution statement for the executor and distribute the final estate funds to the beneficiaries on the executor's behalf. If you are an executor of a deceased estate and would like us to help you administer the estate, call us at Clarke Hemmerling Lawyers and one of our experienced estate lawyers will be happy to assist you.